Sorry about that. That still surprises me after umpteen webinars. So good afternoon to everyone. Thank you all for joining us this Friday afternoon. My name is Hamsa Vijayaraghavan. I'm the Chief Operations Officer at the Migration and Asylum Project, which many of you probably still know as the ADA Trust. I would like to firstly extend a warm welcome to all of you, but especially to the panelists who've agreed to take out their valuable time and to share their expertise and insights with us on the refugee protection framework in India. I'm just going to give a very brief introduction of MAP's work for those of you who may not be familiar with us, and then I'll hand it over to my colleagues to take this through, and to the panelists, of course. So MAP was set up in 2013 as India's first dedicated center for the study of refugee law and forced migration. Our objective is to fuel systemic change in India's approach towards migration and displacement. And the route we adopt to try to do this is by enabling this population to access mainstream legal systems. Obviously, all of you know that India is at the heart of migration in South Asia, and that we have a host of internal migrants, but also those from outside of our borders, refugees, migrants, whatever name you may choose to call them by, as well as internally displaced persons who have been forced to leave their homes due to conflict, persecution, natural disasters, and even abject poverty. And that is a whole different argument as to whether that qualifies for migration and what kind of migration, but I'm not going to go into that right now. To achieve our objective, we run programs that are based on awareness, assistance, advocacy, and even art to some extent. So MAP conducts a number of community-based legal awareness programs with the aim of providing information about legal rights under applicable laws to the populations that we serve, refugees as well as internal migrants. We provide legal representation to asylum seekers in their asylum process at the UN Refugee Agency, which is the UNHCR. We support the development of policy in this arena through strategic litigation, legislation, and advocacy. And we also undertake a lot of stakeholder and public engagement work to change the popular perception of refugees and to make India a safe space for those who seek protection here, but also to inform what we call duty bearers about this population to sort of wake them up to their needs. In all the years that we've been working, nearly 9 years now, we've noticed a very acute lack of awareness, not only amongst refugees of their rights, because their legal status is ambiguous, so they often don't know what services they can access, but also amongst legal practitioners and civil society about the needs of this community. So to address this, last year, we came up with an open source handbook, which is available on our website, to which I think all of you have the link, and if not, we're very happy to share it later. The handbook basically, it attempts to demystify the existing refugee protection framework in India and to address the knowledge gap amongst legal practitioners and human rights defenders with respect to the rights available to refugees. With that, I won't take up any more time. I'd really like to get the panelists in as soon as we can. I will briefly hand it over to my colleague Prabhat to take us through the handbook before we proceed to invite the panelists. So Prabhat, it's all yours now.
Thanks, Hamsa. A very warm welcome to all of you. Thank you for joining us today. I just have a very short presentation on the handbook. It won't take too much time. I'll quickly just take all of you through the chapters that we have, and the objective of developing the handbook is something that Hamsa has already covered. Just give me a moment. Let me just share my screen, please. Is my screen visible to everybody? Okay. Just a minute. Sorry. Okay, this is a little, yeah, okay. Is this visible to everybody? Is it okay? Yeah, okay. So, as Hamsa already said, one of the major reasons why we developed this handbook is so that we can also broaden the movement within India. We can involve more lawyers, more civil society stakeholders, academicians in this. Just sort of having this webinar, having this panel discussion has introduced us to so many new faces, people, like such eminent people we've not had a chance to interact with previously. And we're very glad that this is just a very sort of a very welcome change. We've also, the handbook, this handbook, it being for legal practitioners, we've tried to cover all aspects of refugee protection in as much detail as possible. But like Hamza said, it is a live document. We do intend to upload, sort of modify it, to update it every year. I'll quickly take you through the objectives, which is to equip legal practitioners, judicial stakeholders, HRDs. We have a parallel series known as the Know Your Rights booklet, which is more like an abridged version of the handbook. And I'll quickly take you through that at the end of the presentation as well. This is something that a lot of people who must have received an invite email from us would have seen. One of our main objectives is to develop a referral pathway. So for now, the community, they are heavily reliant on the UNHCR, and they find out about us through word of mouth in the community and the UNHCR as well. But there aren't a lot of visible refugee rights advocates or organizations providing support. And what they also don't realize is that they need not only get support from MAP or from UNHCR for a number of matters, especially internal matters, domestic matters, that they can seek help from other organizations. For instance, gender-based violence is a huge problem in general, and the situation has really worsened during the lockdown. And for them to be able to seek support from any organization that's working in this space with marginalized populations is an option. And that's what we've tried to achieve through the booklet. Show them these things, give them names of organizations, present this information, tell them what is punishable under Indian laws. There's not a lot of awareness about that either. So through this referral pathway, what we hope is that their access to these civil society stakeholders, to legal practitioners, to these NGOs is facilitated easily. They have the sort of know-how on how to approach an NGO for help. And of course, also create a resource sharing forum just in India and in the South Asian region as well. We previously launched the handbook on a regional level in March. And at that time also, this is something that we had definitely spoken about, that we want to have a dedicated legal forum where we can share updates, because that's also a way for us to understand, given that all countries in South Asia come from it's a very similar situation. Even one sort of a positive update in one particular context can serve as a best practice model in other contexts as well, which is why a resource sharing forum is also very important for us. So how we went about developing this handbook is essentially, we've been in this space for 8 years. So a lot of desk research, at least when it comes to the domestic framework, the existing domestic framework, the international instruments that India has ratified and has an obligation to follow the provisions of which. We've heavily engaged with the community, with community members. Over the years, we've developed relationships with a lot of community members. And in a way, the pandemic gave us this opportunity to sort of focus our attention on this. So we were constantly talking and consulting and trying to understand the practical access to various facilities, because what this handbook, apart from detailing these laws, does is also talk about the practical access to various facilities that refugees have in the country, so that when legal practitioners are, for instance, if they're approached by a particular community member or any other organization, they already have an idea on what the general situation is like and can advise them or refer them to another organization that may be in a better position to help them. So we've, of course, engaged with stakeholders, with UNHCR, of course, with CHRI and other experts. And like I said, we've been here for 8 years, so some sort of an organizational experiences, like that's also counted for a lot in helping us streamline the process and understand what are the particular, even within the aspects that we focused on, what are specific aspects that we definitely sort of needed to shed more light on, because those are problems that, say, the community has brought to us or something like that. So the handbook has been basically divided into 5 chapters. These are just these are just the titles. I'll quickly take you through those chapters. So with Chapter 1 talks about the access to asylum. So there are refugees in India under the UNHCR's mandate and under the government's mandate. Our organization, of course, specifically deals with the UNHCR mandate refugees, but we wanted this handbook to be such that individuals and organizations working with refugees in India, irrespective of whose mandate they're under, can sort of take some form of guidance from this. We've, of course, detailed out India's commitments under the domestic framework and under its international commitments. And that's sort of our general theme under each chapter, wherein we've focused on the domestic framework and India's international commitments. We've sort of talked about the existing framework, the policies that the government has implemented or the lack of them, and also various judicial pronouncements that recognize various aspects, say the right to asylum, right to seek asylum, the right to education, access healthcare, where courts have stayed deportation. So this is how we structured all our chapters. And at the end of each chapter, we focused on best practices in various countries in South Asia and in Southeast Asia. South Asia is more relevant for us, but there just aren't as many best practices. So we've also broadened our search to Southeast Asia. We've explained the detailed dual asylum procedure. Then the next chapter focuses on the access to rights. So we've essentially covered 9 rights, including that to education, healthcare, family unity, employment, again, domestic framework, judicial pronouncements. And in particular, there are a lot of judicial pronouncements with respect to education and healthcare, some with respect to family unity, and that's something we found in the Sri Lankan context. So we've also drawn from that. Now, as I had mentioned earlier, that even within the aspects that we focused on, there are certain specific points that we felt needed more information. So with respect to the refugee community, the right to employment is incredibly important for them, because the lack of financial resources is something that's a problem across the board. Now, due to the lack of proper documentation, more so the proper government issued documentation, there is no formal channel of employment for the community. There is no recognized right to employment, which essentially forces them to seek employment within informal sector. So we have a lot of people, even during our interactions at times, our caseworkers are surprised themselves, because there are people like us who may have a law degree, but they have to work menial jobs because they don't have simply the right to work in the country. So this is something that we've tried to explain. Even in our community interactions, we get a lot of questions on the practical access to employment, and it's a difficult conversation to have with them, but it's one that at least provides them clarity. Then the next chapter, so this is sort of a very broad chapter in which we've covered 3 essential points. The first is documentation, identity and travel documentation that's issued by the UNHCR and by the government. Even so, we've spoken about the documentation issued to asylum seekers. What is the documentation they get when they're recognized as refugees? And also the government issued documentation, which is the long-term visa or the documents issued to the Tibetan community or the Sri Lankan community. And of course, because Sri Lankan and Tibetan communities have been issued government documentation, it has been easier for them to access services like employment and tertiary education, which is something that's completely beyond the bounds for the refugee population under the UNHCR's mandate. We have a very specific policy for the Tibetans, the Tibetan rehabilitation policy, which is not something we see for UNHCR mandate refugees. We have to draw from other policies, government policies that are more general, and we have to sort of try to interpret and just expand their sort of scope to the refugees under the UNHCR's mandate. The next aspect is legal protections. Whenever we have community interactions, a lot of the community members are honestly surprised to even know that Indian laws are applicable to them. That, you know, that for instance, something as simple as they can file a complaint for theft, and them having this information is a huge source of sort of it's I mean, for the lack of a better word, I'd say a little empowering for them to know that they can do this, that they can approach the police, they can approach organizations who can get them the required legal aid. We have a very dedicated section on victims of trafficking, especially in light of the Rohingyas coming into the country. This is something that's very important to identify the international protection needs of victims of trafficking. Also, because with respect to domestic legislations, so for instance, we have the Foreigners Act, the Passport Act. These are provisions that don't recognize refugees as a special class, and hence they are meted out the same treatment that any other foreigner will be who doesn't have the required documentation. But victims of trafficking are recognized as a special class, and they are not subject to the same punishment under these laws. And it's important because some asylum seekers coming into the country, especially from our eastern borders, they might be victims of trafficking. So even during RSD or the frontline responders to this, they also need to sort of have the capacity to identify their needs and refer them to the respective organizations, which is what we strive to do through this. The next aspect is durable solutions. Refugees, of course, the community really wants to learn about resettlement. India does not have a lot of scope for local integration. We've spoken about why the lack of a domestic asylum framework has impeded that. Voluntary repatriation is, of course, the ideal solution across the globe, not just India, but it's becoming more possible. It's becoming more difficult. And just in general, I mean, we're all witnessing what's currently unfolding in Afghanistan, also the situation. So for instance, Pakistan has been voluntarily repatriating lakhs of refugees to Afghanistan. But now that whole sort of dynamic will change. I mean, there's going to be a paradigm shift. We might have an influx of Afghan refugees in a number of countries as well. So we also have to rethink our policies and how we can best sort of facilitate their access to asylum in our respective countries. The next chapter it covers detention. It explains what immigration detention is, the nature of immigration detention, how it's different from administrative detention, the constitutional guarantees. I mean, with increasing instances of refugees and asylum seekers being detained, the second point here is very important because prison management systems are under the state's mandate, which makes it sort of more, I mean, it's under their mandate, right? So there are a lot of makeshift detention centers. You must have come across in recent months of a lot of cases, especially of the community from the Rakhine state. This in particular is important because we also speak about alternatives to detention. We talk about the rights of the community in detention, the most important being the right to legal aid and the right to sort of get a fair trial, which most refugees do not have access to. It's something that they have complained about, that the lack of quality legal aid available with the population. And the only way for us to address that is to get more lawyers invested in the subject matter and willing to do this work. The last chapter is on deportation, which is, of course, a consequence of detention. So indefinite detention is a huge possibility. Also, one, because the community is not aware of their rights, and two, because there are no special laws that particularly sort of deal with the population. So again, in this, we've provided possible arguments against deportation. Non-refoulement is the most important, of course. The recent Manipur High Court judgment that one of our panelists will later reflect on has set very good precedents. It sort of I wouldn't say a light at the end of the tunnel, but it's just like one sort of like, it was just a pleasant surprise, is how I can say it, reading that judgment, because it recognized all of India's obligations. Not only did it recognize it, it held the government accountable. It facilitated the refugees' access to asylum. So it basically did everything. It covered all 5 aspects of what are covered in this chapter. And which is why, and that's of course possible because you've the lawyers involved in the case were able to present that case in a manner which allowed that, and which is why it's important. Again, I'm just restating the importance of the handbook. um, when you get deported, asylum seekers are at risk of refoulement, of course, and
I think he's gotten frozen, which is just as well because he's really well past his time limit. We'll give him 5 seconds and then I think we should just move on. He's at the end of his presentation now. So. I think we'll move on. Radhika, if you would like to take over, I'm happy for you to.
Thank you, Prabhat, for taking us through the handbook. My name is Radhika, and I'm a fellow at MAP. Once again, I would like to extend a very warm welcome to everyone attending today. We will now be moving on to the panel discussion and hearing from our distinguished panelists. First up, we have Dr. Manoj Kumar Sinha. Dr. Sinha is the director of Indian Law Institute, New Delhi. He has been published extensively in the fields of international human rights law, international humanitarian law, and international refugee law. He has also been associated with the Michigan Refugee Law Group, headed by Professor James C. Hathaway, as well as the International Association of Refugee Law Judges. He will be sharing with us his insights on India's refugee protection policy, including a historical perspective on the refugee movements in South Asia, the need for a domestic asylum law, and the challenges in enacting and implementing such a legislation. Dr. Sinha, I invite you to take over the floor now.
Thank you very much, Radhika and Hamsa and all other panelists here, and Prabhat specifically, because he asked me to come here and he assigned me 3 important tasks, as Radhika has identified: that historical perspective more on the South Asian context, the need for a domestic asylum policy, and India's refugee protection policy. If I start this topic, as a student 20 or 30 years back, when we heard Justice J.S. Burma and then also Professor Chimney, he taught me also how over the years they have changed also. Like, initially Chimney was not very keen for the India becoming party to the 1951 convention, and subsequently, so the more you come to close to the end of your career or something, you shift your line of thinking, but that is altogether different. Even Justice J.S. Burma, long time back, I remember 96, 97, that time he was judge of the Supreme Court also, he spoke about there is no need of refugee law in India, because there is a constitutional guarantee and constitution applies to everyone, particularly Article 14, 21, 25, and others article also available to all. And Supreme Court and High Courts, right now Manipur Court has been also cited. And I also remember, Irene Khan, then High Commissioner for the Refugees long time back, and Mahiga was a great person who tried best to convince the government of India to become part of the 1951 convention and 1967 protocol. And he started his argument on that particular point, because whenever government authorities or any person who used to take a different point of view. He said that since India is taking care of a lot of refugees. If you become party, you are already fulfilling the obligations. You allowed us to function from here. You fulfilling all the obligations. There is no harm at such India becoming party to the 1951 Convention and 1967 Protocol. And also India can consider to adopt a domestic law for the refugee. It did not work out. Then we have in 1997 eminent persons group that suggested also the model law for the refugees. A lot of development has taken place over the years, but we are in the same place. If you today we sit in the 2021, so where we were in 1990, we are more or less on the same junction, same thing. We are keep on thinking about that. And I think that government has almost firm opinion, because I get some opportunity to talk to the government officials closely, some of my friends in the government officers. So they have almost a rigid view. There is no need of India becoming party to the 1951 Convention, 1967 7 Protocol, because it's more Western ideas of refugees. So that's like, they always say there's no need of becoming party to the 1951 Convention and 1967 Protocol. So what is alternative we have? So if I go to my second and third point, if I take the need for a domestic asylum law and India's refugees protection policy, should we continue with the way government of India and also with the help of the UNHCR is more ad hoc manner we have been handling refugees? It's not a concrete, though we have a large number of refugees. And if I put all together in the South Asian context, so what we see historically also, India's independence in 1947 and subsequently in Bangladesh, creation of Bangladesh in 1971, and in 2012 and 2015 in Myanmar, the crisis. And now I'm sure that again, Taliban is marching ahead. So maybe a huge number of refugees will be generated in the Afghanistan. So root cause, if you see in the conflict, in all three situations, some kind of conflict, ethnic conflict or religious conflict, which has taken place in Myanmar, which has taken place in the religious line in the Bangladesh and for the war also, and India, Pakistan also. So in all these cases we see, and in addition to the movement of people from these all three regions, we have also people coming from the Tibet in 1959, and off and on we have from the Sudan, Somalia, 1-2%, Afghanistan also we have. So we see that all nations, all including Bangladesh, India, Pakistan, Bhutan, Nepal. Of course, Afghanistan is fortunately the only country which has become party to the 1951 convention. So the state which has no concern about the refugee, they are first to become. If you see the International Criminal Court, the first to become party, all the African nations. When the Rome Statute came into operation in 1998, so ratification was very first from the African nation. They jumped in the signing and they said, it gives some kind of image. So these nations were not serious about its implementation on that particular part. We see they become party. So that doesn't make that doesn't help anyway. So it's not. So we have to look into more holistic. And I see that opportunity the way recently in 2018 and 2019, there is one case is pending in the Supreme Court of India, since you people have worked in the handbook and filed by the Muhammad Salimullah and others versus Union of India in 2017 regarding the possible deportation of Rohingya refugees. So matter is still pending before the refugees. And if you remember, there is a request. Why I'm mentioning this case? Because there is a request from the special rapporteur. She has made a request to the court, Supreme Court of India, and highlighting what she said. That is very interesting. What she said, she is a very good terms she's uniquely qualified. She has used so she has forgotten that we have Professor Chimney, we have other people also who knows the international law. So she said she is uniquely qualified to educate the court or inform the court India's obligation under the various international human rights instrument. Like a very young lady, but the way I see say, so I said we are a huge country and we don't have any person to educate. But anyway, that intervention, she said, I'm uniquely qualified and come. And she said, so now she is addressing a issue regarding the deportation, where what she started with, she took help of the various international human rights instruments. That's like India has obligation under the Racial Discrimination Convention, CEDAW Convention, ICCPR, ICSR. There are 6-7 human rights instruments she has cited in that particular. So India's obligation. So what her intention is, would be, of course, is a good intention, that she mentioned that she wants to inform the court about India's obligation under the international law. So the way attempt has been made to enlarge the scope of the various international human rights instruments for the protection of the refugees or protection of the Rohingya. So they did not focus that India, and of course the principle of non-reforma has been cited because it's become part of customary international law. You can't force people to go where their life is endeavored. So we see that there is a scope, like, India can be, government of India can be sensitized or convinced we have broad obligations, and that obligation part will take also how it applies to the citizens and non-citizens under the various international human rights instruments, including the Universal Declaration of Human Rights. That happened in that particular case. And the another interesting case, which is Dev Mukherjee case, which is in the 2020, March 2020. And this time again, the High Commissioner herself, Mitchell Wachett, High Commissioner of the High Commissioner for Human Rights. So the High Commissioner is the principal office in all human rights, the principal coordinator at the international level for the implementation of the human rights. So when the High Commissioner is not an ordinary person, a very great responsibility and great position she holds. So she also sent a request for the intervention in the Supreme Court that is related with the CA case. Again, she has also highlighted the same point of view about the India's obligation under the various international human rights law. She said that section 2 to section 6 of the amended Citizenship Act is discriminatory. So discrimination becomes very fundamental. So when we look into the human rights, so what we have to always remember, non-discrimination, equality before the law, equal protection of law are the we have very cardinal principle of the international human rights law. It's a base, non-discrimination and equality before the law and equal protection of law. So see also highlighting that various international human rights law. So as a scholar or as a all what we have, what I got it, that the international refugee framework. So when we talk about the international refugee framework, it consists of not only on the UN Convention on the Status of Refugees of 1951 Convention and 1967 Protocol. What we can enlarge the scope of the international refugee framework. When you say international refugee law, then we can say, but framework can encompass international human rights law, customary international human rights law, customary international law, international humanitarian law, international criminal law, and of course 1951 Convention and 1967 Protocol that encompasses. So we see the protection of the, so we have to assume, we have to almost accept this reality. There will be no development regarding the national. Manipur court has given that court has a limited jurisdiction that is not going to spread here or Delhi or unless Supreme Court enlarge or something. Supreme Court has done, but each occasion was they are not treating as a precedent. They said this Article 21 is available, but that cannot be the court if directs or something. So we don't see any scope in future where a national law will be become on the refugees, because National Human Rights Commission also wanted, but more or less whosoever is in the position, whosoever comes in the government form, it will be the refugee issues or refugee problem will be remain it's secondary. It's not a primary subject to take note of and then seriously government. It's not the WTO commitment. So trade matter takes priority over all the human rights. So today is patent waiver maybe become very important, and that is important subject. So trade matters have taken over. So trade, if trade is related, investment related, arbitration related, mediation related, these aspects are the priority of the state. human rights and refugees and other aspects are considered in the government office, and also in the other places it's not. So because of the civil society, because of the public spirited individual and organizations like you, stakeholders, they are playing very important role in the protecting of the refugees in India. If I take the another important point, and what she has also mentioned, the High Commissioner, she has mentioned the international human rights law, it applies to everyone, citizen and non-citizen. So it states, so like the moment you accept application of international human rights law, it applies to everyone, that rest of the problem is solved. If we start interpreting on that particular manner, then rest of the problems can be effectively addressed. Just for an example, I'll give you, if I see that Article 2 of the International Covenant on Civil and Political Rights, which says clearly that a state party undertakes to respect and ensure all of the covenant rights to all individuals within its territory. So whosoever enters in your territory, you have an obligation to protect, and that can be linked with the what you have started in your book, access to asylum, that the Article 14 of the Universal Declaration of Human Rights. So everything can be linked with there and state obligation. So best route for today's, of course, we can always continue as our point of view that we should have a separate law. How long you will use the Foreigners Act, Passport Act, Foreigners Act 1946, and Supreme Court judgment that may be useful, but using the existing international human rights instrument, customary international law, or international humanitarian law. If you go and see the government documents, government affidavits, in various cases, even they have disputed what they have disputed. They have disputed about the principle of just cogence, or non-reforma has not acquired. So government of India doesn't recognize official position. It has not acquired the status of just cogence and or fundamental law under the international law. So they said it's not applicable to us. So many affidavit which has been filed before the court by the joint secretary. So we see a very different approach government has while dealing with. And whatever rescue, whatever protection has been granted to the refugees in temporary manner, and even in some cases deportation has been upheld by the Supreme Court of India also. So we have to take note of all these developments. We need to shift our approach. We need to shift the way the two special rapporteur and Office of the High Commissioner, they argued. We have to also enlarge and say, you, whether you become a party or not, it's up to the state. But still you have a broad obligation for the protection of the refugees. I totally agree. There is a need to have a domestic law on this particular, for the domestic law to deal with the refugees in India. That will always helpful for the in defining in granting the status of refugees, or some other mechanism should be in the place. I think I'll just end here. So these are the points which I wanted to share with all of you. Thank you very much.
Thank you, Dr. Sinha, for sharing with us your valuable comments on India's refugee protection policy. Thank you also for sharing with us your insights on the changes and developments in refugee law policy over the years, and for highlighting the need for a holistic solution to protect refugees, including by using existing international human rights law and other international obligations as a means to do so. Thank you once again. We will now have Dr. Nasreen Chaudhry. Dr. Chaudhry is a professor in the Department of Political Science at the University of Delhi, and is also an executive member at the International Association for the Study of Forced Migration and the Mahanirban Calcutta Research Group. She has authored publications on various issues, including displacement, citizenship, border control, and cross-border movements. And she will be talking to us about the practice of sanctuary and the politics of belonging in post-colonial India. Thank you. Dr. Chaudhry, please welcome you to take this.
Thank you so much, Radhika, and thank you so much, Matt, for having me here. I guess one of the aspects of COVID is when there's a lot of connectivity happening despite all the hardship. So I'm very honored to be here. and I hope to share some of my work. It's kind of something that I will read it through. I've titled this as a practice of sanctuary and the politics of belonging in post-colonial India. Providing sanctuary is embedded in cultural norms of individual nations, though their adaptations involve an inherent variation due to the differences in modalities of law, rules, and regulation that are applied on everyday basis. Yet, hospitality provided constantly negotiates the spatial factors whereby being inside is privileged over coming from outside, where inside, outside are constantly positioned against each other. Those who have been inside consolidate themselves as us by constantly differentiating them from the outsider, that is the other. The territorially trapped gaze that is prevalent in demarcating the individual as us and other on the basis of spatial margins or boundaries could be largely ascribed to the predominance of the modern nation state. Towards this, one needs to delve deeply into the practices of sanctuary in post-colonial India based on the framework of citizenship as belonging to understand how sanctuary provisions eventually transmute to identity-based protection. It is imperative to note that the trajectory of protection that evolved in the Indian subcontinent from the colonial period to the later post-colonial imprints, the movement of marginal, or the migrant labor across the border to work in plantation or other imperial military expedition was determined by the imperial need to appropriate the colonial resources of the crown. Interestingly, the strategic alliances that princely states and petty kingdom did not necessitate protection or practice of political sanctuary. The consolidation of erstwhile imperial borders to the territory of an independent nation was coherent with the transition of the colonial subject to the political subject of the sovereign nation state, as argued by Shamadar. Unlike the homogeneous state formation in the Western nation states, the newly independent nation states formed out of violent partition of erstwhile empire created splintered identities with multiple fault lines along ethnicity, language, and culture. Consequently, partition resulted in an ambiguous belonging for these political subjects who internalize as sacrosanct the territorial borders of the new nation state. The vestige of the same colonial legacy proved instrumental in understanding how India's citizenship law was a temporal and spatial project imbibing the essentialities of modern nation state that was habituated to exclude and limit instead to include and embrace. Thus, the construct of citizenship facilitated the perpetuation of territorial gaze of distinguishing between us and them, depending on, of course, which side of the border one was located. The affinity for various primordial identities like ethnicity, religion is significant in the constitution of citizenship. Such affinities need to be introspected through a post-colonial lens to understand how the very same citizenship that is vital for political inclusion becomes vital in segregation, differentiation, reputation, even for refugees who seek protection. In an overt illustration of how the colonial past still shapes and apprises the post-colonial present, the South Asian countries, the protection regime of refugees in India still conflates refugees with foreigners through the Foreigners Act of 1946. When analyzed empirically, the refugee status of these nations are more than often not based on legal refugee framework, rather on a case-to-case weighing in the kinship affinity or strategic relation with the country of origin of these refugees. As Shamadar asserts, the refugee policy of any country is an account of how it takes care and limits care to a segment of people who are not its citizen. So having a concerted refugee policy or not having one at all is just a reflection of how any nation state wields and extends its power to include and exclude. Based on the semblance between us and the other refugee groups, varying degree of hospitality are performed by the Indian state. In the case of partition refugees and the creation of Rehabilitation Finance Administration Act of 1948, showcase India's responsibility that transformed the regime of rights to that of regime of charity for the refugees. Similarly, the Tibetan refugees were supported using various rehabilitation and resettlement plans, along with the provision of registration certificates, and even the permission to establish Tibetan government in exile under regulatory supervision of the Indian government. Such an approach was considered as manifestation of a balancing act where the state's performativity of hospitality carefully weighed between a Derridian notion of politics of hospitality and the ethics of hospitality. In comparison, the hospitality that the Tamil refugee from Sri Lanka received in India could be attributed to the cultural proximity to the Tamils in India, which kind of had a debilitating fault line between us and them, where the host could see a semblance of them in the guest. Arguably, protection or sanctuary was largely based on an understanding of vulnerability and a continuation of Indian state's obligation to a legacy of state performativity of hospitality. An analysis of the political membership of individual institutionalized through Indian citizenship is necessary to understand how provision of sanctuary is indeed intertwined with identity of the claimants. There is a distinct disguised hyphenation that exists between citizenship, nationality, and identity, such that despite being an independent variable in the analysis of political membership, they occasionally act in mutual congruence to designate the contours of exclusion from the same political membership. If being a national facilitates the default attainment of rights for a citizen, not being the same limits a non-citizen to a very minimal basic set of rights. In the Indian Constitution, the provision of Part 3, such as Article 14, that is right to equality, Article 21, right to personal liberty and life and liberty, Article 25, the freedom to practice and propagate one's own religion, are guaranteed to non-citizens as much as to citizens. So legally, one can presume the commonality between citizen and non-citizen to end there. However, what we notice in the case of South Asian countries, and more specifically in India, national identities are tied to the legal position by virtue of citizenship laws, and thereby facilitate the carving of boundaries of inclusion-exclusion based on the same citizenship laws. This is evident in the way the temporal and the spatial construct of citizenship instituted by the state becomes markers of enabling, disabling individuals from attaining the membership of the state. The legality of the citizenship discourse in India lets it oscillate ambivalently between encompassment and closure, creating a differential layering of citizenship as argued by Roy. The post-colonial state of India has inherited not just the administrative state apparatus of its colonial masters, but also the classification of the colonial subject to distinct categories. Such categorical segregation was based on a territorially rooted belonging, as that can be visible in the branding of Chakmas in India, Biharis in Bangladesh, or estate Tamils in Sri Lanka. Yuval Davis and others have perceived belonging as denoting the emotional dimension which entails love for one's own country, hatred for the other, who has the potential to pollute it, and fear and anxiety regarding the perpetual threat of the other and constitute to our cultural purity. Roy opines that the Amendment of Citizenship Act of 1955 showcased the centrality of migrant to the discourse of citizenship. The cataclysm of partition and the subsequent state building of post-colonial India required the Citizenship Act of 1955 to be perceived as limited but largely inclusive definition of citizen that validated associational belonging. The provisional and the temporary protection these groups receive at entry point as refugees can be attributed as performativity of hospitality that involve both the political responsibility and the humanitarian concern of the state. But the eventual amendment in 1986, 2003, 2005 brought about a negative bias to the migrant within quotes, conflating it with illegality within quotes, thereby segregating the migrant as the other. The precarity of asylum seekers encompass the anticipation and uncertainty that state is compassionate and provides care, but being sovereign might exclude few based on curated narrative of territorialized belonging. As Ferrier has argued that while providing asylum through its authority, state has the authority to include or to exclude. The sovereign state needs to showcase certain kind of power which constitute and based on legislative narrative. This legitimate narrative presupposes that one seeks refuge as someone who does not typify the stark contrast between us and them, rather as knowledgeable and nameable figure which is unknown completely. It is the narrative being of the absolute other that causes the state to offer conditional hospitality to many refugee groups that cross its border. To host the absolute other, guests have to have the potential to indeed not to stay for long, but to leave at some point. Any permanence to protection offered to them will cause the margin between the guest and the host to become obsolete both spatially and temporally. The space where they exist and the duration for which they coexist, even the medium such as language through which they negotiate such coexistence, all of these contrive a common platform that distinguishes the fault line. The absolute other is always on the other side of the margin and that should not be breached. So I think what I wanted to showcase in this paper was to give you a sense of the sanctuary provision that exists in the Indian context, because I know the panel has a lot of lawyers, so I'm sure you will be able to extrapolate that. But I think as somebody who is within the domain of political science, I really am very intrigued, not necessarily by the fact that why India did not sign 1951, but more intrigued by the fact that why India seemed to be having a very interesting policy or no policy at all. And that's what I have attempted to navigate in this terrain when I talked about the idea of or the practice of sanctuary. I'll stop here. Thank you so much.
Thank you, Dr. Chaudhary, for your valuable comments, especially on how the idea of citizenship is based on colonial ideas and experiences, and how going beyond such a framework becomes important to protect refugees in India. Thank you also for highlighting how the Indian government continues to differentiate between asylum seekers and refugees based on illegitimate and politicized factors, and for the lack of any policy on refugees that exists in India. Thank you again. Next up, we have Mr. Bablu Loitenbaum. Mr. Loitenbaum is a legal practitioner and human rights activist based out of Manipur. He has worked with Aram Sharmila, organizing various legal and political campaigns for her cause. He was also one of the core members of the team of activists and lawyers that were able to secure access to asylum for Burmese asylum seekers through the recent Manipur High Court case. He will be sharing his insights on strategic litigation as a means to secure justice for marginalized populations. I welcome you to take the floor now.
Thank you so much, Radhika, and thank you to MAP for giving this platform for me to share some of our experiences from Manipur. The two presentations that went before me were also extremely insightful. First of all, laying out the framework, legal framework, and also the challenges, but also getting into the real dynamics of identifying refugees. And we can also resonate a lot to what was already said. Coming specifically to the context in which we are working, it would be perhaps useful for us to understand the context of Myanmar and the Northeast. If we go by what the whole ethnicity and the way our response to refugee crisis is involved, I think it also resonates very well with why the central government's response to this particular crisis and the state government's response to this crisis are so very different. It would be interesting that this is not the first time that we are seeing a refugee crisis. In fact, it goes much beyond. Even during the Second World War, refugee crisis from Myanmar was something that people have talked about, especially when the Japanese were making the aggression in 1942 to onwards. There were streams of refugees that was coming from the Myanmar side, and before the Japanese army actually came across the border from Myanmar and the Second World War actually played out in Manipur and in Nagaland. But coming closer to the present, the 88 crisis was also something that we all remember. And there, again, the response from the government of India at that time and this time was also very different. At that time, I think that was during Rajiv Gandhi's time, and also people like George Fernandez, for example, would stick his neck out to support the democracy movement. And camps were being set up in Manipur where Burmese refugees would come and officially stay there by the camps being set up by the government. But this time, the response was very different, because on the 10th of March, for example, there was a notification from the Home Ministry, which clearly directs the Assam Rifles, which is the paramilitary group, which is guarding the borders in this area, and the state governments to check the flow of illegal migrants coming into India from Myanmar. So there were very clear instructions to the military, the intelligence, as well as the state government, not to allow the Myanmar nationals who are going to run into towards the India side was quite obvious. And this came a bit strange, and also because many of the people in the northeastern states share not only a long border, but also a long history with the processes, both political as well as social, economic, and even demographic connectivity with Myanmar for centuries. There was a natural empathy that people felt when this crisis was unfolding, and especially when India's response was so dramatically different from what it used to be in 88. So you see that in Mizoram, there was a different kind of an approach. The government openly said that these are our ethnic brothers, because the Chin and the Mizos are very closely linked, and they could even speak to each other, even though the language was slightly different. They could communicate quite well. So the Mizoram government responded saying that we are going to open camps and we are going to allow them to stay, giving territorial access and basic food and shelter. I mean, and they lobbied very hard with the central government to be a little more moderate in their response. Whereas Mizoram was ruled by a more, a regional party, the Mizo National Front. They have that elbow space to have an independent kind of a policy. Whereas Manipur was directly ruled by BJP, and therefore that kind of an elbow space was not available. So the first response from the Manipur government was also a letter that was written to all the district administration in the border district. There are 4 or 5 borders districts, and clearly stating the district administration of the border, as well as the CSOs, forbidding them from opening camp or providing shelter and food to these quote unquote immigrants from Myanmar. But what was interesting was there was a big response from the civil society, and we ourselves moved to the Manipur Human Rights Commission and said that this violates not only Article 21 of our Constitution, but also Article 14 of the Universal Declaration of Human Rights, and Human Rights Commission being there to uphold this kind of standards. We expect them to declare this notification or the letter as null and void. That created, of course, a ripple effect. And on 29th, the government of Manipur, also because they don't want to be the bad guys and seen taking a position which is very unpopular, had said that their 26th March notification was misconstrued, and they said the government of Manipur will continue to provide humanitarian aids. So that was an interesting development, also because of the civil society's response and also using the Manipur Human Rights Commission. But unfortunately, when we look at the ground, nothing happened. Many of these people have already moved in from this porous border, and they were living with the villagers in this border areas with absolutely no help from the government. So they were depending upon already marginalized and poverty-stricken villages to share the food and shelter of whatever they had. So we waited for some time, nothing happened. So what we did was we form a committee. There was already a committee called the Citizens Committee Manipur, which involved many prominent citizens of Manipur. And we said that if government is not providing the humanitarian aid, then perhaps it is for the citizen to wake up and do that. So we started, mobilizing resources locally and started supporting this host organization, host villages, which were supporting these refugees. So in a way that sets a context wherein the civil society was raising and trying to respond to these. And of course, we also wrote to the Prime Minister highlighting that we should be more humane to these people, because after all, they are also running away and they are getting the brunt because they are fighting for democracy and principles that this country stands for quite clearly. And specifically coming to this case that was being quoted a lot nowadays, among other things, I think it was also because it was Nandita Haksar, who was also fighting way back in when the 8888 thing happened, and she was also there in Manipur. She was then much younger, just passed out from JNU, so a lot of spirited activism that she did in Manipur, and she was contacted by the Mizima newspaper journalist who was stuck in the border town of More in Manipur, and so she came all the way from Goa, and she, being quite an authority in this subject herself, was able to carefully argue with the human rights, the High Court of Manipur. Initially, in fact, many of these journalists who are stuck in the border could not even come to the capital Imphal, where the High Court is located. So we have to get specifically first an order from the High Court to grant them the permission to come to Imphal. Many of the they could not even get their no Haute Commissioner was ready to sign on the affidavits that they were supposed to submit to the High Court. So with a lot of difficulties, carefully and with the support of the local community, both at the border area as well as in the state capital, we were able to bring them to Imphal and then put them at a secure place. Only then the High Court was able to adjudicate, also looking into the merit of the case. And many of these journalists actually were also people who were in India already in the follow-up of the 8888. Many of them were actually have been given gracious visa to India, and because they were in collaboration with Prachar Bharati programs of the All India Radio. So there is no question of the concern that there could be a national security threat. So the court was completely convinced about the genuineness of their case. So finally, again, reading into Article 21, the principle of non-reforma, which unfortunately even our Supreme Court has not done. So it was quite a step forward, and we were all very pleased to see that at least these 7 people, 3 journalists of Mizima, including their family with even children, were able to go to Delhi and apply for their refugee status to the UNHCR. However, that being the happy story with an happy ending, there are thousands of other people who are still languishing in a very difficult situation in the border area. In fact, 29 of them are arrested in the border district of Churachandpur, and they were put in a detention center, which is designated as a jail, sub-jail, and two of them have died recently. Two ladies have died because of COVID infection. And interestingly, even though they are put in the detention center, their food was never provided. They were arrested on 31st of March, but till now, the government has not provided food and no medical treatment. So we are now again raising this issue with the Manipur Human Rights Commission. One, that this lady who died on the 6th of June, after they were already put in the judicial custody for 3 months, more than 3 months indeed, should be considered as a custodial death, and all the formality that is there in terms of our guidelines that is provided by the National Human Rights Commission on custodial death needs to be followed, and that these people deserve to be treated as any other prisoner, and they are entitled to right to food as well as right to health care as any other person, because Article 21 is not just about citizen, but it's about all the people. All persons have the right and liberty enshrined in Article 21. So that's why the struggle continues. Besides these 29 people, there are various estimates of how many people are actually stranded on the border. The estimate goes to anywhere between 20,000 to even larger numbers, but nobody really knows how many are actually stranded. So even though 7 people were able to take advantage of this very good judgment, there are still thousands of people who are not able to avail of this judgment which has come out from the High Court. And the most critical question that I wanted to raise here is that, see, many of these people, some of them want to go back as soon as possible, but many of them actually want to apply for refugee status. But the norm that is currently practiced in India today is that, one, applying directly to the government of India is next to impossible, because they are not going to, once you start accepting one, then everybody can claim. So that option doesn't seem to be available to them as a practical, viable option. But even to apply for UNHCR, the condition is that you have to be first staying in Delhi. Only then can you apply and the process will start. This is ridiculous, because how can 20,000 people from Myanmar, from the Myanmar border, from Mizoram and Manipur, even imagine of going to Delhi without even identification card with them? Even these 7 people who were with the High Court, giving clear instruction that they should be allowed to go, they had lots of difficulties in the airport because they couldn't produce an identification card. So it is an impossible task for these 20,000 people who are stranded in the border to think of even applying for an asylum status. So this becomes, that makes the whole legal norm that is available, whether it is at the national level or the international level, become quite meaningless for many of these people who are stranded in the borders at the moment. If there is any possibility, if MAP can take up this case, or if there can be advice that the very learned panelists can provide, it will be very useful, because this is a big burden. And even to give humanitarian aid to these people is becoming problematic, because they are living with tremendous fear, because the moment they are identified, they can all be thrown out, because it is in violation of the Foreigners Act, but also a specific notification that has come from the central government on the 10th of March, as I was telling. So they are living with lots of fear. And even to provide humanitarian aid to them becomes a problematic issue, particularly with all the NGOs under scanner because of FCRA. People are scared to even give them help because then they might be framed again as supporting and helping the illegal immigrants and thereby collaborating in illegal activities. So these are some of the dilemmas that people on the ground looking at the Myanmar, specifically the Myanmar refugees are witnessing. Well, I can go on and on because this is the crisis that we are deeply stuck at, but let me stop here and I'll be happy to share my other thoughts if there are concerns and issues that is raised during the question hour. Thank you very much.
Thank you, Mr. Leutenbaum, for your valuable comments, especially into the politics behind the state response to the refugee crisis and the role played by civil society members and lawyers, and highlighting how shared ethnicities played a role in the state and non-state response to the crisis. It was also extremely interesting to hear about the behind-the-scenes effort that went on behind the Manipur High Court judgment, and also thank you for highlighting the practical limitations of a High Court judgment and the continued plight of asylum seekers. Thank you once again. Our final speaker for the evening is Mr. Ajay Varma. Mr. Varma is an advocate practicing in New Delhi and has represented asylum seekers and refugees held in detention centers before various courts. Mr. Varma is also a senior fellow and country manager for India at the International Bridges to Justice and has extensive experience with international human rights law and international humanitarian law. He will be talking to us about challenges faced by legal practitioners India's political obligations and exact arguments that can be made on behalf of refugees. I'm sorry, was I audible, Mr. Varma?
Yes.
Yeah, you can start. Thank you.
Okay. Thank you, Radhika, Prabhat, Hansa, for inviting me for this wonderful panel discussion. And I'm thankful to Dr. Manoj, Dr. Naseem, Mr. Bablu in sharing their views on it, especially Mr. Bablu in sharing the practical issues which is being faced by his organization, him, in Manipur. As overall, all of you have seen, as I am not the expert in this area, but whatever I will share, I'll share with the experience in litigation before the court and what are the hurdles, what I've come across during these interventions in assisting the asylum seekers, detainees, foreign national prisoners, and other foreigners detained in jail in various parts of India. Now, as you have seen that these international convention, India is not signatory to this refugee. No legislation is specific to asylum seeker. The handbook which you have prepared, sorry, I forgot. I wanted to congratulate you that this is really a good tool for lawyers, especially for people, young lawyers, to have a bullet points, bullet judgments to use it while doing litigation for these asylum seeker or refugees. And it may be upgraded and updated also with the latest judgments such as Manipur and the various other Delhi High Court and other High Court judgments. So the story revolves around the various Foreigners Acts, Passports Act, Citizenship Acts. The hurdles faced by these refugees are mostly faced by this. Yes, if they have to apply, as Mr. Bablu has said, the practical difficulty is they have to come to Delhi to apply for registration before UNHCR. But one interesting thing which is I wanted to share with you is, are they not entitled for legal aid? In fact, everyone fulfilling the criteria is the 3 lakhs annum and 5 lakhs now it has been increased, is entitled for free legal aid. So their litigation, the MAP and various other organizations, we have seen the trend so far as the legal service authorities have not been supporting these cases. One of the reasons is people have not been approaching. The second is lack of awareness whether this applies to them as well. So according to me, I have got many people, especially the refugee and foreign national prisoners, to get approached the authorities, legal service authority, and got the legal aid. Those in detentions, Article 21, my learned friend Mr. Bablu has said, and Mr. Sinha has also said, there's no discrimination whether Indian national or a foreign national. Everybody in jail or detention center is entitled for free legal aid at the state's expense. The another rider which I put it here is legal aid at a state expense, but it should be an effective legal aid to those persons. Definitely, because there is no point in just for the name's sake appointing a lawyer who is not even filing the application, not representing, and the dates are adjourned. So this is one of the issue which is faced by the refugees, foreign national prisoners, or detainees in various detention centers. The another hurdle is access to counsel. Legal aid is there. How many of them are visiting these detention centers? How many of them are visiting these prisons? Especially how many of them have access to their own lawyer is a big challenge, because if they don't have access to their lawyer, they are deprived of the real issue, the representation before the court, and the voice doesn't go to court. And I'm sharing a story, a story of last year. In pandemic, last year in June, you all know that the Honorable Supreme Court directed the prison to be decongested. But the foreigners in detention center, especially in Delhi, it is not managed by the, it is managed by the Delhi government, run by, controlled by the FRRO. The right, in fact, the fighting happens because of food, because of the lack of medicine, and the fresh cases were registered against the foreign nationals, waiting for deportation, or waiting to go back to their country after their acquittal judgment has been passed in their favor. The issue came to our knowledge in another client who was there in jail. We raised it in Delhi High Court, and somehow was able to secure a visit of a judicial officer to see the condition. And let me tell you the condition. The people, they were much happier in Bihar than the detention center, because no medical facility. There was one person who is still waiting to be deported, though he has been out. Every day he is on dialysis. He was not able to allow to take medicine from outside. No family communication. Food, the condition of food quality was really pathetic. No blankets, proper blankets. So this is, I am talking about a center in Delhi. You can imagine the situation all over India, that because the prison is the last subject which the state considers, and these detention centers are the least bothered areas where these authorities are concerned, that there are humans who are in these centers and they require assistance. Yes, respective cases, they may be getting support from the lawyers. The issue of health, yes, issue of health is a crucial issue which is not effectively being given in these detention center. Then comes to the legal aid. Now, I have talked about Delhi. I have come across, not much far from Delhi, a detention center in Noida. And there has been people who are there more than 6 months waiting for their deportation to their country, and there is no legal representation. And they have to approach to the Allahabad High Court to seek a remedy because of illegal detentions. So these are the challenges which the inmates faces, but the problem what lawyer faces, accessing to them. Thank God to the technology being used recently. Yes, in some places video conference access is provided, but for a lawyer, it is difficult to represent a person unless and until he has the wakalatnama in his favor. The authorization appointing him as a lawyer. Yes, in some places, meme of appearance is allowed, but for getting wakalatnama, let me share with you, it took 1 month for a Supreme Court case when I forwarded the wakalatnama to the detention center in Delhi. So this is another big hurdle faced by the lawyers while representing these clients, whether it is refugee, asylum seeker, or any foreign national prisoner who is requiring the representation before the court. Now, as I said, that Article 21 does not discriminate. Anybody who is foreign national, who is a victim of torture, who may be victim of a crime. There has been instances that there are rape instances happened and the person is afraid of visiting to the police station. Sexual harassment happens, as your handbook also covers these areas. They are having full right. They can approach to the legal service authorities. They can approach to the court for direction against the accused or the authorities for such tortures. Now, the biggest hitch is this. When they approach to the court, what they face is, will my status be revoked? Will I face multiple cases? The police authorities try to put them in multiple cases if they try to speak up. So this is one of the hurdles which the lawyers face when their victim approaches them, and then we are trying to approach to the court. The victim says, I don't want to take the risk, rather than I would like to keep quiet. So this is a really serious issue which we have to work on collectively. Now, so far as the FNPs, foreign national prisoners, are concerned, the law, fair trial, speedy trial, effective legal representation cannot be differentiated with vis-a-vis the Indian national. They have all those rights as available to the Indian national, because Article 21, as I already said, it is available to the foreign. But what is the biggest hurdle? The biggest hurdle is a person, suppose from Myanmar, from any other country, can't speak Hindi or English, and he is there in the court facing this trial. A lawyer can't speak those languages, requires an interpreter. And let me tell you and share with you that many places, many times in the trial faced by them, these facilities is not available, not given. Even the person who is elected, I'm going for a step, one more step, that the person who is an Indian national and can't speak English, and if the proceedings are happening in other language, the cross-examination or the statement of witnesses happening, these challenges comes with the lawyer. These challenges come, so therefore the lawyer need to seek directions to have an interpreter. Now, most of the times we have seen the foreign national prisoners, either the asylum seekers or those who raise their voice, are also roped into the narcotics NDPS cases also. I'm not saying all the cases are false, but there are some incidents that has happened. Again, in those cases also, a language has been a big barrier. And then even if they are able to secure bail, as your handbook also talked about, the bail bond are not available. Now, let me share an example what happened 2 years ago in Delhi. Foreign national prisoners lodged in jail reported and written to me, as well as the Honorable Chief Justice of Delhi High Court, that they are not getting bail. For 4 years, 5 years under trials, they have been in jail. I was appointed as an amicus, and I conducted the study for entire Tihar prison and interacted with all the foreign nationals. One of the shocking things came out was that they have been discriminated in respect of consideration of bail because they are foreign nationals. Whereas the Article 21 does not talk about. There has been a judicial precedent, but this is overall thing which came out. Even if they are able to secure bail, they are not able to fulfill the condition in those bail. If a person, even in detention center, recently got certain order that he should be out, the condition he was not able to fulfill. There has been a recent case in Delhi, the story which I am talking, that the condition came out in the knowledge of court. There was allegedly a Pakistani national, but he has wife and everybody relatives in Delhi, in Kolkata, and we came out and we requested the court that this is a person who has been acquitted on this issue and has an Indian national. Despite that judgment, he took 6 months for his release, and the court is not only found the condition of the detention center, but then there was a condition imposed. That condition was not fulfilled. So this is another hurdles. Now the one of the hurdles lawyers also faces is how to get them out, where on a personal bond or cash bond, because mostly courts wants to have them present during the trial or during the proceedings, whichever before the tribunal. That is the main principle. But in the absence of surety, the people are still in jail because they are not able to fulfill. Now, easiest issue I can tell you is the person came to a valid visa, foreign national person, but the visa expired under 14 Foreigners Act. He has been detained. He has been arrested and kept in jail. Very few, most of the time they've been asked to plead guilty, but very few get bail because the conditions are so strict that they should have a local surety, which is contrary to the law laid down by the Supreme Court. So this is one of the challenge which we face in the hearings. Now, Another issue, which I think you have also touched some of the thing is in your handbook, is repatriation of prisoners act. The repatriation is also an important aspect, because people who are in jail, who are sentenced, foreign nationals or people in jail in India, they can be repatriated, but the process takes time. But how many of the, except few NGOs, I have not seen the processes being moving forward. So therefore, the collective lawyer group requires that this should be represented. Now, the last but not the least, I also want to point out that the issue of detachment from a family member. A recent case of a person having everybody, family members living in Delhi and not having, and was being about to be deported. Immediately the intervention was that we filed a petition in the High Court and got some order of his stay on deportation. Normally, very rarely the Honorable Court stay the deportation, but we could succeed because of the family. Then there are other issues, the access to the case paperwork. Case paperwork, that is one of the biggest challenge, and I think Mr. Bablu will also share that this, with the help of technology, it can work out. But when Delhi has this issue, you can imagine that various part of other India also has a issue of a lawyer doesn't get access to the paper so that he can assist. So these are the certain issues which I wanted to highlight. As being a defense lawyers, I'm more on the strategies, and I think what Mr. Bablu has talked about the judgment in Manipur, and I think the similar petitions, similar issues should be raised before the various other high courts where these refugees, where these asylum seekers are facing this. And as one of the panelists talked about, that the people died without lack of food. Yes, the condition is so poor that the food, in fact, would not be sufficient enough to feed them. They are not being provided that sufficient food. And that's why there should be an auditing of all these detention centers by the Honorable High Courts, by appointing some commissioner or anything, because unless there is a judicial intervention, the things will not improve in these centers. That is my last point. Thank you so much for giving me opportunity to share my views on this.
Hi, Radhika, are you there? Okay, I think my colleague dropped out, but thank you, Mr. Varma, for your comments on the practical challenges around providing legal representation to refugees and the difficulties in accessing alternatives to detention, which is something we've also tried covering in the handbook, but there are a number of practical limitations to that. Also, thank you for highlighting the importance of bridging the awareness gap around legal aid for refugees and asylum seekers. That's something that's a major issue with the community not being aware that they have access to lawyers all over the country. It's also that even when there is the odd occasion when news is reported, they aren't able to sort of really get access to that. So this is very important. I know it's 5:30, but I would request if it's all right with the panelists, if we can have a short 20-minute question and answer session, if all the 4 panelists are fine with that. We have a few questions that have come in. If the panelists are fine with that, can I go ahead with them? Dr. Chaudhary, Dr. Sinha, is that okay?
Yeah, fine. No problem.
Thank you. So the first question, Dr. Chaudhary, I'll address. I'll take up the question that's been addressed to you. The question is, what do you think are the limits of viewing belonging through the lens of citizenship? That is, how does citizenship in itself dismiss other ways of belonging? It's a fairly technical question for me too. Yeah.
Thank you so much for the question. And again, I must say, this is such a great way of learning, especially for some of us who are not in the field every day. See, the whole issue is one of the cases for South Asia is, and especially the region is very unique. Is that my mic? No.
That's be mine.
Okay, so I think one of the aspects, at least in my work, because I'm not a lawyer by training, so we do talk about in terms of case laws and things. But coming back to the subject that I am comfortable to speak on is, how do you determine, differentiated rights of refugee groups, especially considering India has a vast number of refugee groups that are coming in, and they are giving some level of protection. So the lens that I have actually used is, the whole idea of belonging to the context of citizenship. Because when you have, fundamental rights, which is basically determining that the provisions of the Constitution apply equally to the citizens as well as the non-citizen. So I think citizenship law is, or citizenship is one of the prism to explain, what distinguishes them. Now, the larger question that has been asked here is, should that be the only one? No, of course not. But in the case of South Asia, what we have technically noticed is, given the overlapping and aspirational aspect of culture, kinship, language, and linguistic similarity that exists, and of the cultural construct, has given a unique understanding. And therefore, citizenship appears to be one of the real, because how else do you explain, as Mr. Bablu was saying, that here is a civil society basically saying we want to keep them, right? The law does not have enough mechanism to do so, but you have an empathy emerging from the community at the border areas where refugees show up. So I think in that sense, the politics of belonging becomes a very, very important aspect to unravel the question for. So yeah, thank you.
Thank you, ma'am. I'll move on to the next question. That's for Mr. Bablu. The question is, should strategic litigation in refugee protection issues be taken to lower courts? Would that be more effective than going to the Supreme Court? And just to, sir, make it a two-part question, I think another question has been posed, which is sort of a precursor to that, which is that how do we ensure that, so like Mr. Ajay spoke about lawyers in Delhi, but in the remote parts of India, and particularly the Northeast, where there are a lot more cases of detention, arbitrary detention, indefinite detention, how do we ensure that legal practitioners are able to, not just that they have access to legal practitioners, but that information is there, that there are cases of so many matters of detention? And yeah, from there, drawing on from that, like how does strategic litigation play a role in sort of bringing that to the forefront?
No, absolutely. No, I think at this point in time, that's the only tool that is available to us as citizens, as activists, as lawyers. Strategic intervention is extremely important. The unfortunate part of it is that the quality of our legal aids lawyer is extremely poor. Good lawyers are not empaneled in the legal aids, and good lawyers usually don't have time to take up these cases, right? So I think there is a certain level of encouraging bright young minds to be engaged in it. I think this is very, very critical. If MAP can organize a similar webinar, bringing some of the finest lawyers in the country, and I'll be very happy to identify some of these lawyers who are handling it, I think that would be a very worthwhile exercise that we can do together. Yeah, and I mean, when we do litigation, one is the lawyer, the other thing is, of course, the judge. How sensitive is our judiciary, and particularly the lower judiciary, to this matter is also a very grave concern. So I think organizations like yours who are focusing specifically on refugee issue, I think we need to do a lot more work in sensitizing the lower judiciary as well. There is a tendency to look at a refugee issue as a zero-sum game. Very often people think that if they come stay at our country, how are we going to provide them food, and because we are already overstretched in our resources. Honestly, what we are seeing in Manipur and what we are trying to advocate also to our politicians is that, see, if you don't document them, they will anyway get in, because for them, if their life is being threatened, they will somehow find a way to get in. If you don't document them properly, if you don't have a kind of a designated camp as it was done in 88, then they will sip into the population. They will corrupt a SDO to get an Aadhaar card. And that can be much more dangerous in terms of, if you are trying to protect your whatever population from being polluted, whatever, what is required is a clear policy of dealing with this matter. So I can go on and on again, but I also see a question in the chat box. Since we don't have much time, let me also tackle that. How are we going to replicate this story that we have done in Manipur for others? I think every place has its unique dynamics, and it might be impossible because people feel that somehow Burma is connected to us in some way. There was a response from the civil society. I wonder whether it will be the same case when the Afghan refugee comes to Haryana tomorrow. It might be a different response, but nevertheless, I think it has to come. The fact that a larger understanding of not only international law and international legal framework, but also refugees can be actually an asset to your own society rather than seeing it always as a liability would be, I think, important. After all, Albert Einstein was also a refugee once upon a time, right? So how do we positively engage with the refugee is perhaps important rather than seeing it always as this dirty, dependent, pest kind of an attitude. They can also bring a lot of, we have to accept them as people with equal dignity, and who knows, there could be, we have to accept that they are endowed with dignity and respect as any other human being is. I think is very core element that needs to be recognized when we are talking about a human rights framework. Thank you.
Thank you, sir. I think a very important point you raised is sort of the ethnic familiarity in the Northeast with the Burmese community as well, which is not something that across, given the diversity in the country as well, I think in general, and the way in general, I feel the way the media reports on the population, it's something that's affected perspectives more so in a negative manner. And the Northeast has that advantage of perhaps interacting with refugee communities on a much more intimate level as opposed to the local communities elsewhere. So I think that I do feel that that's something that does play a role in how grassroots level movements are organized. Professor Sinha, if I can bring a question to you. So the question is essentially about the ICJ's Netherlands versus Syria case, 2020, about the torture centers and the victimization of the Syrian people. So can you perhaps comment on that, if that will play an important role in sort of curbing and deterring further crimes against humanity in the future in that context and in other similar contexts?
Prabhat, I have not gone through that particular case, but recently I read that in the International Criminal Court, International Criminal Court, the preliminary chamber, basically they started investigation, they permitted prosecutor for the investigation under Article 15. So regarding the genocide and crimes against humanity, both in Bangladesh and Myanmar. So that development is taking place. And of course, there was another earlier case, I believe, regarding the genocide in the Ghana versus Myanmar in the International Court of Justice, or Congo versus, just I'm missing that one. So that case also court. So like we see number of principles have been developed, not just like a new phenomena, which has been by the International Tribunal and also by the European Court of Justice. European Court of Justice has developed a formula in 2009 case, subsidiary protection. Protection. So it's not a permanent protection. They say, okay, if somebody has entered and his life is in danger, so state members, state of the European Union, that is 27 members, have an obligation to provide a subsidiary protection for the temporary period, not a permanent. So don't go in the status, don't go in the crisis, you provide for 5 years. So they have also some, what we are seeing, the countries who played very important role in the development of international law, as like development of international refugee law, particularly European nations, they themselves are not very keen to apply. So they have alternative mechanism which has come already there under the under the European directive principles of 2004, and there are a number of development in Europe continent has there. So cases are of course if International Court of Justice or International Criminal Court, it's a good for academic purpose, but the real challenge which has been identified by the Bablu and by the Ajay Varma ji, I believe those are the challenges. It's huge. Even in India, deportation, nobody is ready to give the. They don't have anybody to help them to for even bail has been granted. Or there are no access to lawyer is a big issue. So it seems very okay when we discuss and we talk about. So international principles are good, but how it has to be locally addressed. What has been suggested, I believe.
So if I can just sort of maybe ask you a follow-up question on that. Particularly in the aftermath of COVID, there were a lot of questions surrounding the principle of non-refoulement, and I think even Miss Gillian Triggs, who's the deputy chief of who's the deputy human rights commissioner, she also spoke about how the struggle. I mean, in a way, we are back to right where we started from, which is just like the struggle to get countries to follow the principle of non-refoulement, just get them to comply with that. So if you can just maybe comment on that also a bit.
No, I said in the, and I'm surprised also, I said in the beginning. So as there's no doubt about, there's no ambiguity, uncertainty about the term Article 33, which has acquired the status of very fundamental law and principle, part of customary international law. So I mentioned, and I have seen, and you might have also seen the affidavit which had submitted by the Joint Secretary in the case of Salimullah, where they have officially, so affidavit by the government officer, they said we don't recognize as a principle of customary international law. We have always objected. So there is no doubt it has acquired the status of and just cogence and very fundamental law, and states should respect. And if states start respecting, including India, then half of the problem will be solved. Deportation. Supreme Court has also upheld the deportation. Staying the deportation order by the courts, it takes a lot of it's a challenging task, and I'm sure that lawyers. So I feel that when we talk about the principle, no doubt. We always say in the classroom, courtroom also, people might have argued, but when it comes to the implementation part, there is interpretation, and particularly state objected. I believe that in 2000, when the Citizenship Amendment Act was discussed in the Parliament, and the Home Minister was there, and certain officers were just cogence was also discussed. And our Home Minister have said it has not acquired. So the just cogence was raised by the Congress, and I remember the Manish Tiwari, he raised, certain principles are there, which is very fundamental. You can't discriminate, you can't send back. But in a Parliament, this issue was discussed about the just cogence. So government has a different, take altogether when it comes to the respecting and recognizing the principles of the non-reform.
If I think just the last question for the day, if I can have Dr. Chaudhary and Mr. Varma both comment from the perspective of academics and the practical application of it, specifically with respect to India's border control policies and the immigration policies. There's an acute lack of data available. So how do we inform policy in terms of sort of conducting any sort of empirical analysis on how we can maybe improve the conditions of detention, on which Mr. Varma spoke extensively, which will also perhaps help in advocating for alternatives to detention when we are presenting cases? If maybe Dr. Chaudhary, if you can first go on.
I wish I had a perfect answer, Prabhat. But I can tell you that, as social scientists, we have to kind of, heavily depend on, the panel members that I have here, they would be of huge help in terms of figuring out case laws. That's one. But having said that, I think what your specific question is, there the data is being maintained by some NGO. Government probably has it. If you were to, let's say, the case of the Myanmar nationals that came to, let's say, West Bengal, or the languishing in jails. Phenomenal work has been done by MCRG, some scholars who have worked, and I believe the way they went forward was to visit the jail and dig out the registry, or where the cases are, or where inmates are languishing. So in other words, what I'm trying to get at is, there is no ready-made database, and perhaps that's where your organization plays a very crucial role in building it from the scratch. So that is one of the lacunae that we definitely face in relation to non-citizen. I'm not talking about just refugee, migrant. I'm just going to say non-citizen, right? So that is completely a problem. And what Mr. Bablu was saying, that this is often being seen as a zero sum. So whoever, nobody wants to come forward and do anything. So for me, when I went to do my field work in Tamil Nadu, the government wasn't the way. I went to the official channel with some police officer. So they have more knowledge than, let's say, the various parts. So this is kind of unique case where we can say how we do research. We shouldn't be doing that. Perhaps things will change. I mean, if a change for good, it's good. I mean, we should have access. So at least that is a way that I, as a researcher, have got access. So there is no ready-made database. So I don't have an answer, as I said, but that's how we navigate it.
That's good, but one of the biggest issue comes is access to the centers. Even if the lawyers are not allowed to access now, unless and until these access are there, condition cannot be told. So therefore, what happens is, one of the strategy we adopted is that the client, anybody, a lawyer's group, any client communicate to his lawyer, and if he informs him, there are ways that they get information by not specifying the particular person. Just get some of the information, the condition of detention center, then do the approach to the court. And I think with that perspective, I'm just sharing my view, the experience which has changed the view of the detention center in Delhi, because even the inmates started messaging us. That sir, the food is properly given. Now we have got the blankets, sir. We have got, sir, water filters now. So this is the situation changes when you get information, but without naming it, sharing with your lawyers group, and then approaching in the court, because you should ensure, we should ensure that the information is not false. Also, because if we are approaching the court with one solid, strong ground, and it happened, luckily in our case, that a judicial officer went to the jail and he gave report. And the another issue is the cases of the people who have been acquitted. Now, as you said, that the people, foreign national prisoners, acquitted in the cases, and they are likely to wait. They have to go back to their country. Still, they are languishing in detention centers because they are waiting for deportation, because the state wants to appeal, despite there being MHA circulars that has not been implemented. So in those states, the writ petitions is a strategy which we lawyers do. And therefore, I think in order to improve the condition, this is a collective efforts of lawyers group would be really helpful.
Thank you, sir. Thank you, Dr. Chaudhary, for answering that question. I know there isn't a perfect answer, but just sort of maybe to get that conversation going on the importance of having some sort of quantification, some quantitative data to inform policies. I think that's the end of the questions here. I'll let Radhika I'll let Radhika take over from here.
Thank you, Prabhat. On behalf of the Migration and Asylum Project, I would like to extend a vote of thanks to all our panelists today for that very insightful and invigorating discussion, and for being kind enough to stay beyond the stated time. Your perspectives today have greatly enriched our understanding of the different facets of refugee protection. I would also like to thank everyone who attended the panel discussion for being such a patient and active audience, and for bearing with us through technical difficulties. Finally, I would like to thank our donors and supporters, without whom we could not be doing this work. We are very grateful for their support. We hope that today's panel discussion marks the beginning of the discussion around refugee protection in India, and we at MAP will be establishing a network of researchers, activists, and practitioners who work on refugee law and policy. We welcome every one of you to be a part of that network, and we'll be contacting those who have already indicated their interest in being a part of it. The handbook is available for download on our website, and we're always looking for feedback and are available to ask any questions you may have and open to collaborations. We hope to be in touch with you all, and thank you and have a pleasant evening.
Thank you. Have a good weekend. Bye-bye.
Thank you so much. Thank you.
Thank you.
Thank you all.
Thank you.
Thank you.